Hello and welcome back to Coin Lady channel. Ripple, the SEC has been beaten again, and this time XRP comes out on top. When do you anticipate the court's ruling to be made? When do you think you'll have enough wins to convince the judge? In today's video, we'll discuss the latest developments in a case from this past year and answer all of your questions. Ripple Labs has won yet another court case against the United States. By Judge Annalisa Torres discloses that she denied her ex's plea to seal the case of the infamous Ponzi scam. Despite the US SEC's request, the court rejected the SEC challenge to Judge Sarah Net Byrne's decision to seal the Hinman speech records because they contain internal agency conversations. Statement were shielded by the attorney-client privilege, or the deliberative process was rejected by Judge Net Byrne. The Commission, on the other hand, has claimed that certain confidential documents should be shielded from public view because they are relevant to the pending summary judgment proceedings. Disagrees with the US SEC, and that the Hinman speech memoranda are legal documents that must be made available to the public. The court concludes that the contested documents could aid the judicial process and are thus relevant to the court's exercise of its judicial duty. Brad Garlandhouse, the defendant in the XRP litigation, has commented on the recent victory against the US government. Another triumph for transparency, he said. Added that all of Hyman's correspondence and business documents would soon be made available online. The court also dismissed the Commission's argument that secrecy is required to preserve transparency and honesty. The ongoing Ripple vs. SEC court battle has taken a surprising turn as US District Judge Annalisa Torres denied the SEC plea to seal documents concerning the Hyman statement. During the discovery process, Judge Sarah Net Byrne issued a long order requiring the regulatory agency to hand up the records to Ripple. The SEC moved to seal information, including texts, expert reports, and internal emails, pertaining to Hyman's comments on December 22 ND, 2018, stating that the public's right to access such documents exceeded the agency's goal. Meanwhile, Judge Torres hinted that the Hyman's papers could be considered in the final ruling. Former SEC Corporation Finance Division Director William Heinemann's letters and comments are included in the relevant files. The authority denied in 2018 that Ether was a security. The files also contain the SEC's initial thoughts and research on XR, as XRP is the subject of his initial thoughts. The documents are essential to the argument that Ripple's make. A recent court judgment has authorized the securities regulator to remove names and other identifying information from documents filed by powerful individuals. Additionally, Torres approved Ripple's proposed omissions. However, Judge Annalisa Torres decided against certain redactions, including XRP, and allowed Ripple to delay the release of the contested diamond files until June 13. SEC Division Director William Hyman's 2018 summit address pronouncing Ethereum Ether and Bitcoin BCA, not securities, were among the documents that were supposed to be made public on June 6th, according to a court order. The judge ruled on May 16. Defense Counsel James Key file and anticipated these discoveries on June 6. On May 19, file and tweeted that Ripple and the securities regulator requested a one-week extension until June 13, 2020, to file public redacted versions of Cross Motions F. The court order on September 9, 2022 specified that both parties had precisely 21 days following the sealing judgment to produce public redacted summary judgment materials. Pro-Ripple attorney John Deaton claims that Division of Trading and Markets Director Brett Redfern told Hyman's that Deaton's speech would cause more market confusion. Tourette, a Fox Business journalist, quoted Deaton as saying this on May 21. Past, Stuart Alter-Rody, chief legal officer at Ripple's, has suggested that the Howey test be interpreted in accordance with the common law framework, citing a U.S. Supreme Court judgment that said legal teams and courts should adjust criteria from ancient cases to match the developing legal context. Court declared in 1976 that art lithographs offered for investment were not securities if the seller had no post-sale contractual responsibilities to the buyer, and he highlighted this decision last week. Good basis to believe that the passage in question does not meet all of the criteria for security status under Howey, and is so exempt from federal securities regulations. According to the email, the legitimacy of Ripple's action depends on XRP and other cryptocurrencies passing the Howey test for securities. If the SEC publicly or privately declares that XRP is not a security, Ripple's case might be rendered moot. Pro-cryptocurrency attorney Bill Morgan suspected a communication was delivered by a Secret Service attorney, and Deaton agreed that the SEC representative may have been paraphrasing another XRP research, and added that a number of attorneys specializing in securities law were likely participating. Some hope that the SEC will release Hyman's correspondence to dispel these rumors. In the past week, Ripple has made a number of announcements aimed at expanding its platform. CEO Brad Garlinghouse cited potential for expansion outside the United States as the impetus behind Ripple's $250 million purchase of Medical. According to the crypto payment company, its platform is compatible with the XRP blockchain and token. James K. Filing, a defense lawyer and former federal prosecutor, expects the contentious Hyman speech materials to be made public on June 6. A former director of the SEC's corporate finance division named Bill Hyman made comments in 2018, the topic of the Hyman paper, implying that ETH was not a security. Discussion and debate regarding the relevant speech. Fallon has been following the SEC vs. Ripple case closely for the past 2 years, and on May 17 he informed his followers of the potential for unsealing the files, in accordance with the judgment handed out on September 22, 1220. Yesterday until June 6 is 21 days for the parties to submit publicly available redacted versions of the summary judgment papers in accordance with the sealing judgment. The state's plans, however, might change if the SEC files an appeal or if a compromise is reached. The SEC has about 10 days to file an appeal to this verdict, according to Jeremy Hogan, partner at Hogan, and another attorney following the case. Some in the XRP community, like Ashley Prosper, are skeptical that the prospect of unsealing the papers will induce the parties to settle the dispute amicably, on the grounds that they each may be in possession of information that they don't. Ripple Labs believes this aspect of the case is critical in rebutting the misogynistic assertions that XRP is a security. The SEC asked the court to keep the documents secret at the end of December, citing the lack of importance to the outcome of the case and the importance of the document's contents as justifications for doing so. On May 16, a formal denial was issued. With Ripple Labs' recent success. I hope you enjoyed the video. If you did, please hit that like button and turn on your notifications. See you in the next video. Bye.